Welcome to the Balancing Act podcast. Today, we're exploring the second installment of our Numbers Don't Lie series, Inside Receivership. In this episode, we'll take a behind-the-scenes look at the world of court-appointed receiverships. From business disputes and financial distress to fraud investigations and asset recovery, receivers play a critical role in protecting value and bringing clarity to challenging situations. Joining us are Brian Landau, partner of the SLBiggs division of SingerLewak, and Stephen Donell, president of FedReceiver and an experienced court-appointed receiver. Together, they'll discuss what receivership is, when courts appoint receivers, how assets are secured and recovered, and the collaborative efforts required to maximize value for stakeholders. Let's get started.
Welcome to the second installment of Behind the Numbers. In our first episode, we explored forensic accounting and fraud investigations. Today, we're turning our attention to another important area where accountants and attorneys are routinely involved. This area is receiverships. Most people are familiar with bankruptcy, whether it's Chapter 7, where a trustee is appointed, or Chapter 11, where there's potentially a reorganization. However, bankruptcy is not the only court-supervised remedy available when there's business assets that are in distress or disputes that arise. In many situations, a court may instead appoint a receiver to take control and manage assets while the underlying issues are resolved. To help us better understand what a receivership is and how it works and when it's used, I'm joined today by Steve Donell, president of FedReceiver, an experienced court-appointed receiver. So, Steve, why don't you tell me what is a receiver? That's kind of what everybody wants to know because it's not somebody people are generally familiar with.
Sure. Well, a receiver, first of all, is always appointed by a judge, and there has to be litigation existing in order for a receiver to be appointed. A receiver, by definition, is a neutral, and a receiver is considered to be an arm of the court or an agent of the court or an officer of the court. So the receiver is always the court's receiver, and a receiver could be an individual or a corporation or an entity, depending upon different state laws. And a receiver can be appointed either in state court or in federal court. And there's a lot of different types of activities that receivers engage in.
At the end of the day, the most important part about a receiver is that you're neutral, correct?
That's correct. I would say the issue of neutrality, and I think equally as important is competency, that the receiver is qualified to perform his or her duties.
In receiverships, that generally a state or federal court, you have bankruptcy where that's generally governed under the bankruptcy court solely. So it's kind of the distinction between the two areas. The receiverships happen in a variety of manners. And as I said, it could be state or federal court. When are receivers needed?
Yeah, well, receivers are needed. And there are many common situations where a receiver might be expected to be appointed. I would say as a threshold matter, a court always views a receiver as an extraordinary remedy. So the appointment of a receiver is a remedy. It's not a cause of action. So unlike bankruptcy, where somebody actually files bankruptcy, nobody files for a receivership. There has to be an existing lawsuit, depending upon the nature of the dispute. And then in connection with that existing litigation, a party to the litigation can seek to utilize the remedy, and a receiver can be appointed in connection with a piece of real estate that may be in default. There could be a partnership dispute, judgment enforcement, divorce receiverships, and a receiver can be appointed on a limited basis for something literally as specific as maybe allowing somebody to gain access to a property to do testing for environmental issues, all the way to the most broad form receivership, which is known as an equity receiver, where the receiver is actually appointed to step in the shoes of the owners of the company and does everything, including filing its tax returns, and can ultimately liquidate the entire company. So there is generally some sort of financial default or allegations of impropriety, possibly fraud, a violation of a partnership agreement, or some level of impairment to creditors. Those are the typical scenarios that exist when a receiver is appointed, but the courts want to make sure that there aren't other remedies available that are less onerous than a receivership. And so there really has to be a lot of bad things going on for a court to agree to use the extreme remedy of appointing a receiver.
Okay. And we've seen in certain times when we have a full federal receivership, full federal equity receivership, that sometimes comes about from litigation associated with the SEC or the FTC. Do you have some kind of insight in terms of types of actions that are brought by the SEC or FTC where a receiver like yourself would be appointed?
I do. I've been appointed by both the SEC and the Federal Trade Commission. So the SEC are typically going to be Ponzi-like schemes, Bernie Madoff type schemes, where investors are investing in a company and the company is not engaged in a lawful enterprise. It may start out proper and lawful, and it may kind of turn into a Ponzi-like operation, or it may have been insolvent and fraudulent from day one. And then the Federal Trade Commission involves consumers. So consumers that are paying a company for a service. Right now, for example, I happen to be the receiver in a Federal Trade Commission matter over a company that purported to provide tax return and tax services for consumers all across the country. And in some cases, they did provide those services. In other cases, they provided just a little bit of services. And in other cases, for individuals, they provided no services at all, but they collected a lot of money. We've had other cases involving, with the Securities and Exchange Commission, for example, involving all different types of schemes, factoring receivables, mortgage frauds, where the company purported to have mortgages on properties, and that the investor was secured through deeds of trust on properties, and in fact, they were not secured. There could be other schemes involving, I had one case involving repair your credit, pay us $500 or $1,000 or $2,000, and we will repair your credit. And of course, they didn't follow through with their promises. So there is some promise to a consumer or investor that is not delivered, and there are allegations of impropriety, including fraud and other violations of federal law. And that's known as a federal equity receivership. And the government enforcement agents are involved, and those are civil actions. And in those cases, it's very common contemporaneously with the appointment of a receiver in the civil action for there to be a criminal investigation. And that would be handled by the United States Department of Justice and the FBI. So it's pretty serious stuff, and very often the fraudsters are looking at prison time, assuming they're ultimately convicted.
And what I find interesting in some of these areas and where we bring in accountants and things of that nature, especially in the SEC and the FTC cases, they involve a lot of, from a financial standpoint, tracing of assets, looking for absconded money, things of that nature, of trying to find a way to recover funds for the people that have been damaged. And it seems to me at the end of the day, your job sometimes in those SEC and FTC cases is to try to help the consumer who has lost money.
That's right. At the end of the day, the government is seeking to shut down the operation of the company so that those that have been harmed are not continuing to be harmed, and then also to prevent new consumers or investors from being harmed that haven't actually invested yet. And to the degree that funds are located and assets are sold and liquidated in amounts great enough to return them to the victims, then that often is part of the role of the receiver, which is to institute a claims procedure and then to try to recover the money for those that have been victimized.
And what's unfortunate in some of these situations, we've seen time and again that we shut down, or the SEC or FTC shut downs an operation, that those same kind of bad individuals pop up right again and start the same scheme all over again.
That's very true. I have seen that over and over. And in fact, one of my current cases, that's precisely what's occurring. And I'm getting feedback from investors who are monitoring social media, and they have identified that the principals of the company have started new companies, the NewCo, the 2.0, and the government has been alerted to that and actions have been taken. So these are very bold people. They're fearless. and they're fraudsters.
Okay, so I'm always interested because you generally am brought into receivership cases after the receivership's been filed, the receiver is appointed, and they say do some tax returns, do asset tracing, do things of that nature. I'm kind of interested to understand what happens. Say the judge signs an order and appoints you. What happens next immediately after the order is signed?
Immediately after the order is signed, the receiver generally is going to have to post a receiver's bond if it's in state court. If it's in federal court, that's generally not required. And then from there, it is to go to the physical location where the company is located to bring the receiver's team. Sometimes the government representatives accompany the receiver. Sometimes there's security guards, sometimes there's law enforcement. And the receiver walks in the front door with a court order, and it's kind of like the movies. The receiver says, "Hey, bring the owner to the front of the business." The owner is served, and the receiver informs the owner that the company is being shut down. And from there, all of the employees are interviewed. The receiver's consultants, whether they're accountants or computer forensic consultants, are going to be looking at the books and records, shutting down the computers, making sure that the access to the cloud is terminated, changing the locks to the business, serving the banks with all the banks known with funds with a copy of the court order so that those accounts are frozen, getting together a list of consumer or investors to find out who the customers are, identifying accounts receivables, accounts payables, notifying the landlord, for example, of the business that the tenant is in receivership, immediately notifying the IRS and other state taxing agencies of the appointment of receiver, and then beginning the process of determining the source of funds, the use of funds, and any remaining funds, as well as what assets exist. And it's very common to find that the owners of the companies may have taken investors' funds and purchased real estate, cars, jewelry. We've taken over yachts, Ferraris, very, very expensive jewelry, securities, having to lock down intellectual property, trademarks. So it is fast and furious the first few days. And the receiver is like a conductor with all of his or her staff members and third-party professionals. And it's controlled chaos, but speed and competency are the name of the day. And those first few days can really make or break a case.
I've always found that the most successful receiverships occur when the receiver, the accountant, the attorneys, everybody's working together in this kind of controlled chaos with ultimately the goal is to maximize value for the estate, depending on what the situation is.
That's right. Understanding the goals and objectives day one, along with what the government is expecting the receiver to do, and that would be consistent with what the duties and responsibilities are in the order appointing receiver. So the Bible of a receiver is the order appointing receiver, and it can be anywhere from, say, 2 or 3 pages up to as long as maybe 30 pages. And the receiver is charged with doing a job, and sometimes it is really to just simply maintain and preserve and report and figure out what stage 2 of the case is going to be. Or in other cases, the plaintiffs, the government, or if it's lawyers and with private clients, they may have already performed a level of forensic accounting, and there may already be third-party targets. And this is where we get into fraudulent transfer and clawback litigation. For example, if the president of the company took investors' funds and bought his mother and father a house, well, that house is then going to be a target for recovery for the receivership estate. And something like real estate is you can't move it. It's not liquid, so you don't have as much of a concern, but you record the order appointing receiver in the jurisdiction where the assets are located so that you create a cloud on title of any assets owned by any targets and any of the fraudsters. But it's really the cash. It's the cash, securities, anything that is liquid that really requires the speed. And so having the accountants, the lawyers, the receiver staff, the plaintiffs, meaning the government agencies or the private attorneys, in alignment with what the expectations are during the first day, week, and month. That is where you create efficiency. And then in federal court, it's very common and typical that the receiver would be appointed on a temporary basis, and the receiver would be identified as the temporary receiver. And then, generally speaking, about 10 days after the receiver is appointed, there's a confirmation hearing. And at that confirmation hearing, the receiver is going to do or provide an exhaustive report to the court. And that is where the receiver's forensic accounting team and lawyers have worked with him or her to provide a very comprehensive report to inform the judge as to whether the allegations made by the government were or were not accurate. And as long as the accusations are confirmed to be accurate, the temporary receiver is converted to a permanent receiver. And ultimately, that generally means that the company is, in fact, going to be shut down on a permanent basis.
Okay, interesting. So once you start recovering some of these assets and you identify assets that need to be recovered either through tracing of funds or asset searches, things of that nature, say you have assets, what's that process like?
First of all, it's really important for the receiver to be experienced and to understand the importance of how taxes impact the value of assets. I have found, having done this over the last 25 to 30 years, and I've done probably around 1,000 receiverships in state and federal court, and that would also include a variety of other types of actions, including partitions and provisional directorships and other court-appointed actions. It's really important to understand the tax consequences as well as other secured or unsecured creditors. And so running a UCC1 immediately is important, providing notice to the IRS to find out if the company has been filing its tax returns. Are there liens on the company? And very often it's very common to find that these companies have not kept their taxes current. And that can include federal and state taxes. It can include sales taxes and also payroll taxes. And so those four basic levels, state, federal, sales, and payroll taxes. And then there may also be city taxes. For example, some cities institute gross receipts tax obligations. And so understanding what the taxes are, who the secured and unsecured creditors are, getting your CC1 report back, finding out what assets are and are not encumbered, that is going to then inform the receiver as to what type of net value the company may have. And a receiver typically would employ an appraiser or a business consultant to perform an analysis of the net assets of the company after the debts are accounted for. And that's then going to inform the receiver as to what type of assets can be sold. So if there's furniture, computers, fixtures, maybe those already have debt on them. Or if they're free and clear, the receiver can hire an auctioneer and begin to auction those assets off. There's also receivables that the receiver can look to pursue to the extent that they exist. And then ultimately there's going to be a claims procedure, and the creditors are going to be paid out in the order of security and or priority based upon the documentation discovered by the receiver.
And, it's interesting. I've always found over the years that transparency and communication amongst all the parties is critical, especially with these tax returns. And there's K1s that impact individuals and things of that nature, that keeping everybody abreast to what's going on, clarity on the financials, the accounting, even when you're operating the business or providing monthly reports to the court or parties is critical in these situations.
It definitely is. Yeah. And there's so many moving pieces and moving parts that are happening in the first week or two. So it's critical that everybody is communicating with each other, that everybody's goals and objectives are in alignment, and that the interplay between the CPAs, the consultants, the government, the receiver, the receiver's counsel everybody has to be rowing in the same direction. Otherwise, you get very, very fractured. And that would frankly be unusual. At the level of a federal equity receivership, typically the receiver is going to be very experienced. This is kind of like the PhD of receiverships. And so you have a game plan day one going into a case, and then you implement that game plan, and each of the respective professionals work with their respective areas of expertise. And information sharing is critical. We often host data on the cloud using various platforms to do so that we all have access to the same information. We can populate new data. We can subpoena records. And then, of course, we're getting bank records provided by the banks, and the forensic accountants are doing their analysis. And typically, the forensic accountants are going to provide the receiver with a hot list. Here are the recipients of the largest amount of funds. Here is when those funds were received. And the forensic accountants can sort of drive and steer the boat as it may be with respect to the direction the receiver is going to go in towards trying to recover those assets, and whether the assets are cash, real estate, or other types of assets.
And that's how I see it. Generally, our role in these situations are, okay, this is what happened. This is where the money went. Now, Steve, you go figure out how you want to claw it back, or what you want to do, or how we can recoup some of these funds.
That's exactly right. Sometimes a receiver will file a motion approving a litigation procedure, and it really sets the framework and the goalposts for what type of target the receiver can pursue, and if the receiver may have settlement authority with a target, so that the receiver doesn't have to go back to court every single time. The challenge here is to try to determine whether or not it makes sense to sue a prospective defendant, because if that defendant is judgment proof, does it make sense to spend $10,000 to sue an individual or a company if that individual or company are insolvent themselves? So the receiver really should do a little bit of due diligence, do a little bit of background check on the prospective litigation target, and really make a good informed decision before moving ahead automatically with litigation. Now, filing a lawsuit is very different from making a demand. I've had cases where in the first 30 days, we've sent out thousands of demand letters. And that is very different than actually filing a lawsuit. So when you start making demands against potential targets, then you start getting those responses. And some of the targets are going to be more cooperative than others. And unfortunately, or fortunately, depending upon your perspective in these federal equity receiverships involving investors, sometimes investors actually get back more money than what they invested. And that's known as a winner. And in a Ponzi scheme or a Ponzi-like scheme, there's no such thing, because by definition, the money that an investor receives is money from another investor. And so generally speaking, while an investor may be entitled to recoup their principal, they're generally not entitled to receive their principal plus a return on their principal. And I have had to pursue many investors that made this phantom profit so that it equalizes the playing field for the benefit of all investors. And that can be a very challenging and difficult discussion with an investor if I'm suing them if they're a winner.
Okay, so the name of the game in lawsuits and things of that nature is running a cost-benefit analysis to determine if it will maximize the value of the receivership estate. Even though you know somebody may have improperly received funds, you may not want to pursue an action given the fact that the costs of litigation and other issues may outweigh the benefit for the receivership estate.
That's exactly right. The receiver really always needs to look at the net benefit of any action being taken. Some of the work that the receiver does it has to be performed regardless, taking over the business, changing the locks, serving the banks. But in terms of deciding who to sue or what actions to take that involve expensive third-party professionals, receiver really needs to do his or her homework to make sure that there's a reasonable likelihood. There's no guarantee, but a reasonable likelihood of a net benefit for the estate. That is what the court wants to see.
Okay. So, once we're through some of these receiverships, whenever I come in these situations, I'm always seen as the absolute bad guy. And you're in here to take over my business. You're here to look at my books and records. And generally, we're not there to take sides. And you're not there to take sides. We're there to provide clarity, lay out the numbers. They'll fall where they fall. And that's kind of where you end up. Do you have any other myths or misconceptions that you think people realize about receiverships that aren't necessarily true?
Well, I would say this, that inevitably, a receiver is supposed to take the side of justice, right? A receivership is known as an equitable remedy, and a judge who is administering a receivership estate through the court, that court is known as a court of equity and a court of fairness. What's right? What is the proper thing to do? And considerations regarding, of course, the law and contracts and the conduct of the parties are all weighed and considered, but the courts have very, very broad powers, these equitable powers. And at the end of the day, the truth will drive the receiver to then sort of be aligned with one side or another based upon the facts and circumstances. I have had cases where I've had a partnership, disputes before, and maybe the lawyers that nominated me and brought me in as the receiver, it turns out that their own clients were the ones that were doing the bad things. And so I think that there's a misconception often that the receiver is going to align himself or herself with the party that sought the appointment of receiver. And that's simply not the case. The receiver is going to report in a neutral fashion, and if it hurts one party or another, it shouldn't matter to the receiver. I think another misconception in a receivership is that the receiver is always going to be able to provide a return to defrauded investors. And unfortunately, that's simply not the case because the investors themselves may be subordinated to the interests of others. And the investors oftentimes say, well, then why is this being done? Why do it at all? Well, it's so that those same investors are not further victimized and that new investors or consumers are not going to be victimized further. So it is a shock to the system when people learn that the assets that they thought existed may not exist and that the company is shut down. And it's a very bitter pill to hear that company never will reopen again. I think the final item that would come to mind here is the issue of speed. It is very difficult for consumers, investors, partners, creditors to appreciate the level of analysis that goes into a case, for example, that might have 25,000 investors or consumers with assets located across the country or internationally. I had one case with assets in, I think, 7 or 8 different countries. And it is a very time-consuming process. And the other issue that great concern to a receiver is the level of cooperation that the defendants are or are not giving. And early in these cases, a lot of times the defendants are lawyering up and the lawyers are trying to interfere with the receiver and they're advocating for their clients. And it may serve to sort of slow down the process, and it makes it a lot more expensive as well. So I think speed is another issue that people really can't appreciate how long it can take for a receiver to complete the analysis needed to make informed decisions.
Interesting. Steve, I really appreciate your time and everything you've explained to us. It was extremely insightful in terms of learning about receiverships, the process, and things of that nature. Thank you very much.
Thank you, Brian. I really enjoyed being here.
Thank you for listening to this episode of the Balancing Act podcast, Inside Receivership, where Brandon Landau and Stephen Donell provided an insider's perspective on the receivership process, from taking control of distressed assets and tracing funds to recovering value for investors, creditors, and other stakeholders. Be sure to tune in next month when we explore trust accounting. Thanks for listening.